Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket, and we will call the docket in the cases in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes, and that applies whether there's one counsel or multiple counsel. And if there are more than one of you, you'll have to share that 15 minutes. The appellants have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium, please introduce yourself and then let us know how many minutes to reserve, and we'll set the clock accordingly. Please recall that today's cases are being live streamed and recorded, and the recordings will be uploaded on the Administrative Office of the Court website for public consumption. So be mindful of that. Judge Stafford?
I wanted just to take a moment and thank Judge Clement for being here today. Court of Appeals in the past has been known as a court with 3 different sections, and that's as accurate as far as it goes. But we are one court, and because we are one court, we interchange freely, and today Judge Clement has come to join us, and we're always happy to have him. Always happy to have Judge McGee, but she's here all the time. But Judge Clement doesn't come that often, so we're thrilled to have him, and we just want to say we appreciate you coming down in the rain today.
Well, I must say I would have preferred weather better than inclement weather, but
no pun intended.
It was a difficult drive, I must say. That rain was coming down, and the spray from the trucks was profound this morning. But anyway, are there any announcements or introductions?
No, Your Honor.
Hearing none, please call the first case.
Stevy Ellis et al. Versus Snookums Steakhouse, LLC et al.
Good morning.
Good morning. May it please the court, my name is Adam Johnson. I represent the appellants George and Stevie Ellis, and I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
Thank you. This court should reverse the trial court's granting of the appellee's motion for summary judgment because a bench that flips over and throws one to the ground when someone sits on it is a dangerous condition that should have been removed, repaired, or warned against. This is a premises liability case, and as this court is well aware, business owners have a duty to maintain their premises and use reasonable care to protect their customers from unreasonable risks of harm. A duty to act with reasonable care that includes removing or repairing such a dangerous condition, or if it can't be removed or repaired, then warning of that condition. Most importantly for this case today, a dangerous condition is one that if it is reasonably foreseeable that will cause injury to others, and a reasonably careful person would not have kept the premises in such a state.
Is the primary issue in this case whether the defendant was aware of a potentially dangerous condition, or go ahead.
No, it is not, Your Honor. As you are well aware, most cases do get into basically notice questions when it comes to premises liability. This case is much more simpler. This case is just simply whether or not this particular bench that flips, whether or not that's a dangerous condition. And that's the only question that's in front of this court is whether that condition is dangerous.
So you're saying the question is whether it was dangerous, not whether the defendant knew or should have known.
That's exactly correct, Your Honor.
Okay, all right.
So what is the evidence in the record that indicates this is a dangerous condition?
Several things. Starting at the beginning, so Miss Ellis was there for dinner with her family.
I don't think any of that's disputed, is it?
No, none of that's disputed. When she goes to sit down on this particular bench, and just to be clear, she knows it's there and she's intending to sit down. It's not that she trips on it or falls on it or anything. She's sitting near the end of it, not at the edge, but near the end. And when she does so, it flips over and throws her to the ground. She lands on her right side. And it's such an extent that her husband, who's standing right there talking to her, actually has to block the bench from landing on top of her. So basically like a seesaw. So that's the main question. To your issue, or to your question, Your Honor, there's a couple of things there. First, I think that question goes honestly more toward the notice issue. What the owner, the business owner, knew or should have known, whether or not they should have warned it, removed it, repaired it. And again, I don't think that's the issue before this court, just simply whether or not a bench that flips over when someone sits on it is considered a dangerous condition.
Well, I don't think there's any dispute that she sat on it, the bench flipped, turned over, whatever. So half of what you're saying is undisputed. My question is, what evidence in the record makes this bench a dangerous condition?
Absolutely.
Because if you follow that logically through, every bench is a dangerous condition.
Well, I disagree with you a little bit, because at a basic level, a bench is a bench, and it's not a dangerous condition, but it can become one, as in this case. And to answer your question more fully, there are two things in the record I think that indicate this. One, the backrest was missing, and more importantly, both...
I thought everybody agreed that the missing backrest had nothing to do with this.
It doesn't necessarily, but what is more important is that because the backrest was missing, both Miss Ellis and Mr. Ellis both observed new bolts that were just dangling there on the bench. And what that indicates is that clearly someone from the defendant had been working on the bench, and the presumption then is that they left the bench in a not completed state. I think Mr. Ellis put it in his affidavit that he didn't think it had actually, or they'd started repairs and didn't finish it. And then as a result, that left it in a condition such that when she sat on it, weight distribution's off, whatever it may be. But those bolts indicate someone had been working on it, and that had changed the condition from a normal bench that one sits on to now it's becoming a dangerous condition because, again, it's throwing her off when she sits down.
Don't you need some kind of expert proof about this?
Well, so to my earlier point, Your Honor, I think that, again, goes more toward notice, because most of the case law that gets into the question of basically what did the business owner know, when did they know it, who created this condition, all of that goes into the second elements of premises liability analysis, and that is, how did this condition come to be? Whether was it from the business owner themselves? Was it from the person that got injured? Or usually, of course, some third party or time or whatever it may be. And then the question becomes, did they...
I thought you said a moment ago it was the business owner who had been working on the bench.
It is. I mean, that's our contention, that someone from the business owner...
Is there any evidence about that?
There's not. They didn't keep any business logs. The only testimony they said was, well, we go clean it sometimes.
So when the business owner was asked about it, he didn't know anything about the backrest being worked on?
He did not. He just said they go, they observe, they clean it daily, they see it. Obviously, it's right by the front door, so they see it frequently. But that's all he could testify to. Again, there were no logs. He didn't know much about it.
Okay.
So let me make sure I've got this clear. So you're saying you're basing basically the proof is that there were bolts that were exposed on the bench.
That's right.
And you're saying those bolts appeared to have had something to do with the installation of, or the placement where a backrest would be on that bench.
That's right. So it's, and it's, I think, page 13 in volume 3 of the record. There's the photo of the actual bench. And the backrest is gone. It's just sort of the two metal prongs that come up. And so what they testified to is they saw metal bolts just sort of dangling from those metal pieces that come up.
Is there any other proof in the record on which you're basing your claim that the bench was in a dangerous condition?
The fact that it flipped over. Okay. I mean, I think the fact that it flipped over in and of itself would be an indication, to go back to the case law, that if it's reasonably foreseeable that would cause an injury to someone else, then a bench that flips over would do so. And there's lots of examples of ordinary objects that by themselves would be, not dangerous, but can become dangerous over time. So there's the Basili case with the raised sprinkler head. There's a plethora of cases with floor mats by themselves are fine, but as they become frayed or worn or folded over, they can become dangerous. And certainly even doors. If I'm walking out when I leave and the door falls on me, that could be considered a dangerous condition because a door that falls on someone can cause injury, and a premises owner, a reasonable premises owner, may not keep the premises in such a state. And in fact, that's what we have here. As soon as it happened, as you can see in that photo, they'd actually taken the bench and removed it from the front and moved it to the back and took it out of commission. So I think a bench that flips over when someone sits on it is in fact a dangerous condition because it meets that criteria.
How do you differentiate this situation from the core civic case written by Judge Bennett, which Judge Clement was a panel member on?
So in that case, they had brought her a chair. She had been sitting on that chair for some period of time, the record's not clear, and then as she's getting up, the legs sort of gave out or moved out, and she sort of slowly fell to the ground. And again, I think that case goes more toward the notice question, not who provided the chair, but what was the issue with that chair beforehand? Should they have known about it, warned about it, removed it, et cetera?
Decided the case, huh?
And that's a question that was left open. This case, I think,
It wasn't left open in the core civic case. He says right here, to establish premises liability, a plaintiff must first prove a dangerous or defective condition existed on the owner's premises. The mere fact that a person falls from a chair or that a seat or chair collapses does not of itself establish negligence where there is no showing that it was defective. Without proof of a dangerous or defective condition, an owner or occupier cannot be held liable for failing to take action in order to remedy the supposed condition.
That's right, Your Honor. So I would distinguish this case on a couple of levels. One, again, here it's an immediate action that occurs. The bench flipping over is what is dangerous.
Isn't that exactly what happened with the core civic case? The lady sits in a chair collapses.
She'd been using that chair for some period of time, and then as she's getting up, the legs sort of go out on it. And again, that gets, I think, more into an analysis of the notice issue in premises liability cases. The question before this court is this bench, a bench that flips over and throws someone to the ground as soon as she sits on it, is that a dangerous condition? Is it such that, again, it's reasonably foreseeable that such a condition would cause injury? And our contention is certainly that a bench that flips someone off it as soon as they sit down is a dangerous condition in a way that a chair that she sort of slowly falls off is not. So I think there is a distinction there. And so because there is, I think, a genuine issue of material fact, at least for summary judgment purposes, that a bench that flips someone off and throws them to the ground is a dangerous condition, the trial court's granting of summary judgment should be reversed.
All right, thank you, Mr. Johnson. We'll hear from you again on rebuttal. Good morning.
Good morning, Your Honors. May it please the court, Blake Timms here on behalf of the appellees, Snookums Steakhouse, LLC, and Brandon Manus. The issue presented in this case is not a complex issue. The analysis, we believe, begins and ends with whether this bench at issue was a dangerous condition. I would urge this court to affirm the trial court's finding that the bench was not a dangerous condition because the plaintiffs have failed to submit proof that the bench was a dangerous condition. They argue this evolving theory that the bench at issue must be dangerous because this incident occurred is essentially what they argue. As far as the backrest, I want to address that first. They say in their reply brief in their brief on page 11 that the lack of a backrest only applies to the issue of notice and did not make the bench dangerous. Instead, it is the fact that the bench tipped over when appellant sat on it demonstrates it was a dangerous condition. So the whole argument about the backrest and the bolts, they've admitted in their brief that that's as to notice and not whether it renders the bench a dangerous condition. They say that they understand that simply falling off a bench does not make it a dangerous condition in their reply brief, but their argument is the bench must be dangerous because this incident occurred. He cites to this Basili versus Rain Incorporated case and Martin versus Gaylord Entertainment, and I just want to take a moment to distinguish those two cases. In that Basili case, that was with regard to a sprinkler head with a landscaping company that would protrude 3 to 4 inches from the ground when in use. And when it was not in use, it was supposed to go back flush with the ground. And there was some testimony by the owner of this landscaping company, Rain, that the sprinkler heads failed to retract sometimes. You might have to take your foot or 2 fingers and push it back down. And as far as the wrinkled floor mat that they talk about in the Martin case, the plaintiff and her husband had seen this wrinkled mat at Opryland Hotel, complained to staff, and then had observed staff straightening that mat out prior to the plaintiff's fall. Here we have a stationary bench. They've not been able to point to anything, any proof that it was dangerous or anything that would render it dangerous. And Judge Stafford, I'm glad you mentioned the Calabria case, the Core Civic case, because that was at the top of my list. Judge Clement, I believe you were on that panel. The court cited this Job versus Goodwill Industry case. That was a 2018 case, and said that the mere fact that a person falls from a chair or a cedar chair collapses does not of itself establish negligence where there's no showing it was defective. And in that opinion, the court goes on to say that a plaintiff must submit proof as to the nature of the alleged defect or weakness or why the malfunction occurred. And we don't have that here. They've pointed to nothing as to why this malfunction occurred, any weakness in the bench. Their argument hinges on the fact that, well, it must be dangerous because this happened.
Is this a situation where expert proof's required?
Your Honor, I mean, they didn't take any. They presented no proof. There's nothing in the record to talk about the sturdiness of the bench, and they've not done that. They've not shown that here.
There's no proof in the record about?
No expert proof in the record, no, Your Honor.
Okay, or no lay proof about the bench being unsteady or anything like that?
No, Your Honor. No prior incidents, nothing. And as far as the lack of records of any kind of cleanings or maintenance or anything like that, in Debicki versus Public Supermarkets, this court held that, well, a U.S. District Court held that the absence of such maintenance records is not affirmative evidence of constructive notice. Your Honor, I would ask that the court affirm the trial court's judgment that this bench was not a dangerous condition, and I yield my time if there's no further questions.
All right, now hearing none, thank you, Mr. Timms.
Thank you.
Mr. Johnson, you've got 3 minutes for rebuttal.
Thank you. Again, just to make sure it's clear, she didn't just fall off a bench. I mean, it flipped and she was thrown off. That in and of itself, I
It
think.
flipped from end to end. It didn't fall, she didn't fall backwards. It flipped from end to end.
Correct, like a seesaw, it threw her off, and again, the husband had to block it. So it's a little bit different than just falling off a chair or something simpler like that. This is more akin to a door falling off a hinge and hitting someone.
So your theory is the simple fact that she sat on the bench and it flipped is evidence of a dangerous condition.
The flipping, yeah, the flipping is what makes this a dangerous condition, because then it's reasonably foreseeable that it's going to cause harm to someone. Certainly, to your Honor's point, you know, if this got into questions of notice, then perhaps expert proof would certainly be needed to get into what the premises owner.
If the other side says this is not a dangerous condition, you don't think you've got to come forward with proof showing it is a dangerous condition?
This case is a little strange just because it is just a straight question. Is a flipping bench a dangerous condition? And for purposes of summary judgment, I would say the burden is more on them. We as the non-moving party, the evidence is shown in the light most favorable to us. And so this is just a straight dispute whether or not, when someone sits on a bench and it flips, whether a flipping bench is a dangerous condition. It didn't get into any of the
Saying that issue wasn't raised properly at summary judgment?
Yeah, the only thing argued at summary judgment was just simply this question, whether or not this bench is a dangerous condition.
So it was raised properly.
I mean, that was the issue, yes.
And with the opposing counsel or opposing party saying there's no evidence in the record that this is a dangerous condition, you don't think that shifted the burden?
Again, I think it's just it's a legal question of whether or not this flipping bench, factually, is that a dangerous condition or not? I mean, that to me is the core issue.
Well, the other side doesn't say it flipped. They dispute it flipped.
And I guess this goes back to a genuine issue of material facts, because both.
But even assuming that would be, assuming that the bench did flip, there's still got to be some kind of proof as to why, doesn't it?
To answer your Honor's question, I think that goes toward the notice question, the why question. Why did it flip? I think goes to the concerns in the case law about what the premises owner knew and when did they know it. And that gets into the notice issue of should they have known about it, did they know about it, and did they cause it? I'm out of time.
All right, thank you very much.
Thank you very much. I appreciate it.
We'll take this case under advisement. Call the next case, please.
In re Estate of Corey DeJuan Dupree.